it can happen both directions. Where there's a marriage, where there's a divorce, sometimes there are mistakes made. Let's start out with a marriage situation. Let's say we've got a husband and wife. They're later on in years. They each have assets. Maybe they each have an estate plan saying this is what we want to have happen with our assets when we pass away. They get married and they don't do anything to their estate plan. Let's say that they've agreed, look, yours is yours, mine is mine, mine goes to my kids, yours goes to your kids. But they don't do anything to change their existing plan. If the plan is dated before the marriage and the person that created that plan passes away with a surviving spouse, that spouse is entitled under the law to the same percentage of that person's estate he or she would have received if there had been no estate plan in place at all. And in those types of situations, that can mean that the spouse would be entitled to anywhere from, depending on the number of children, if there are no children, she gets the whole thing. If there's one child, she gets half of it. If there's more than one child, she gets a third of it. And that's the law. So the important thing is that if it's your intention to make sure that the new spouse does not receive a share of the estate, you have to go in and say, hey, I got married. Here's my spouse's name. Here's the date we got married, but I'm intentionally not leaving her my separate property.